So we're going to be looking into Sal Haney's Police Manual of Arrest, Seizure, and Interrogation. And this is the 10th edition that we're looking into right now. We're looking at the top of page 117 of this manual, and here we find the statement. It seems to me quite clear that though every citizen has a moral duty, or, if you like, a social duty, to assist the police, there is no legal duty to that effect. And indeed, the whole basis of the common law is the right of the individual to refuse to answer questions put to him by persons in authority and to refuse to accompany those in authority to any particular place, short, of course, of an arrest. Section 22 of the manual talks about the refusal of a citizen to identify the self. The common law does not require a citizen to identify oneself or carry identification of any sort. Therefore, while it may be the mark of a good citizen to identify oneself when asked to do so, a police officer must not use force to compel someone to identify oneself if he or she refuses. Otherwise, the officer will be guilty of criminal assault and liable to civil damages. And they give us references to a court case, which I'll talk about a little later. Go on. And here, Section 129 of the Criminal Code makes it an offense to willfully obstruct a public or peace officer in the execution of his or her duty. However, the common law has never considered it an offense of obstruction for a person to refuse to identify oneself and thus prevent a police officer from carrying out his or her general duties to investigate crimes. So a lot of times the police officer will say, identify yourself. I want you to identify yourself. And if you refuse to, the first thing that they want to do is they want to claim, oh, you're obstructing justice. You're taking part in the obstruction of justice, therefore I'm going to charge you. However, under common law, as we see here, it's never been considered a crime. It's never been considered a breach of your obligation not to produce an identification once a police officer is asking you if you're not being detained or if you're not under arrest. If you're under arrest, it's a different situation. However, if you're just on the street and they walk up to you and they want to suspect you of something and they want to identify you, mm, here it's saying that they don't have any right to do so. So a lot of times you're out there in the city, no, you could be somewhere, and the police, they want to stop and identify you. They just arbitrarily walk up to you and they want you to identify yourself. Now, the leading case on stop and identify yourself goes back even prior to 1960, Bill of Rights and the Charter of Rights and Freedoms. The common law has always recognized there were limits on police powers to compel a person or to force a person to identify oneself. In order for a police officer to ask an individual to identify themselves, there is a strict context where this can happen legally. If the police officer suspects that you have been involved in a crime, they will approach you and they will detain you officially. They will tell you, we are detaining you. And if they detain you, then they will seek to identify you. Or if the police place you under arrest, then again they will seek to identify you. These are the only two grounds on which an officer can ask you to identify yourself, and they are under the duty to inform you on what ground or reason they are asking you to identify yourself. It's their obligation. Now, in that judgment that we just read, or that was quoted in that handbook, it talks about here. The defendant's two plainclothes police officers on patrol stopped the plaintiff and a friend and asked them for their identification. The plaintiff refused to comply, challenging the officers to provide their identity. So the two cops in plain clothes walk up to them and say, we're police officers, we want you to identify yourself. These two men probably looked back and said, we don't know who you are. How do we know you're police officers? Can you show us that you are police officers? What happened? The police officers then asked them again, can you identify yourself? And the plaintiff rebuffed a second request to identify himself. And then a scuffle ensued and the plaintiff was arrested. So the police again said, no, we want you to identify yourself. And the plaintiff refused to identify himself. And then a fight broke out and they were arrested. Well, who do you think started that scuffle? Who do you think started that fight? The plaintiff then sued for false arrest. The trial judge concluded in the series that the officers were acting on the suspicion that the plaintiff might have been involved in a series of break-ins which had occurred in the neighborhood a few nights before, and were confirmed in their suspicion by the plaintiff's uncooperative attitude. However, the Ontario Court of Appeal reversed the decision, finding that the officers had no reasonable and probable grounds for suspecting the plaintiff. Now, two officers were on the street, and they stopped two individuals and simply asked them to identify themselves. The individuals refused. We later find that the court ruled that the officers had no ground, no reason to ask the individuals to identify themselves. The individuals refused the request of the officers twice to identify themselves, and then a fight broke out. A scuffle happened. I highly doubt it was the individuals who started the fight, but more so the officers were upset that the individuals did not give heed to their request. The two individuals were arrested, and then the officers placed assault charges on the individuals, which were dismissed by the courts. So we see that the officers had no reason to ask the individuals to identify themselves, and when they refused, the officers fought with them and then tried to charge the individuals with assault. This is a plain violation of police powers and abuse of law. Sometimes this is the mentality that you will be confronted with through having to speak to these officers. The individual officer, police officer, somehow believes that he is the law, and what he says or asks is the final authority, when in reality, this is really not the case. In that judgment, it talks about the fact that a police officer has not in law an unlimited power to arrest a law-abiding citizen. The power, given expressly to him by the Criminal Code to arrest without warrant, is contained in Section 435 of the Criminal Code, now Section 450. In addressing this question of the plaintiff by the officers, the judge indicated that he could not fault them for asking him to identify himself, and suggested that if the plaintiff had been cooperative, he would have avoided the difficulties which beset him. However, the officers were not entitled, on his refusal to answer, to use force against or to arrest him. This decision is the authority for the proposition that the police do not have a general right to seek the identity of whom they please. Any right they possess must flow from a recognized power, such as that inferred from Section 450 of the Criminal Code, where there are reasonable and probable grounds for suspicion of the individual questioned. Where they lack such specific legal authority, for example, where they act on mere suspicion, they can ask the question of an individual, but will not be protected from liability for infringing that person's right if he or she refuses to answer and is arrested. It is implicit in this latter position that the suspect is entitled to refuse to answer questions concerning his identity. Since the Charter, these rights concerning identification have been constitutionalized. When you received your birth certificate, the document itself indicates upon it, do not use this to obtain other identification. And even though it says directly upon it, do not use it to obtain other identification, we go and we obtain other identification, and it comes from this first source document. Your medical card that you have is controlled by an enactment here, and this enactment governs the control and use of this card. An individual is only to present this card to a health service provider when obtaining health services. That is it. No one else has the right to ask you for that card, and legally, you do not have the right to use it in any other capacity, whether it is to identify yourself at the local club or to help prove who you are when applying for a membership. You were never allowed to present that card in that capacity. Neither do the police have the right to use the card to identify your person. They are not providing medical services and have no right to draw any information off of that card. Your driver's permit is the same thing. The enactment allows for an officer to ask you to provide this card to him if you are driving a motor vehicle. engage in a commercial capacity. Then he has the right to ask an individual to produce this card. If you are on the street and an officer seeks to identify you and then subsequently uses your driver's permit to identify your person, this is a breach of public prescriptive law. This is beyond what the enactment allows you to do with your card and who can ask you to present that card and when. The rights and freedoms that are in operation in Canada concerning the criminal code and criminal matters are flowing from the international covenants. We have seen how Canada, as a state party, is obligated to fulfill these individual rights and freedoms. The Canada that I'm talking about and that we will be speaking about here in this video, all of us together, is a juristic federal unit. It's the incorporated body. When you look into the Constitution Act of Canada 1867, Article 91, you find the following statement. It shall be lawful for the Queen, by and with the advice and consent of the Senate and House of Commons, to make laws for the peace, order, and good government of Canada. Now in section 91.27 it says, the criminal law, except for constitution of courts of criminal jurisdiction, but including the procedure in criminal matters. So it shall be lawful for the Queen, with the advice and consent of the Senate, to make laws concerning criminal law, and including procedures in criminal matters. Now the Canada that they're speaking about here, that the Queen's going to be making laws for, with the advice and consent of the Senate, is a federal juristic unit. For the Supreme Court of Canada stated that further, although Section 91, that's what we're talking about, gave the Queen the power, with the advice and consent of the Senate and House of Commons, to alter the Constitution of Canada, except in certain expressly designated areas, it does not confer a power to amend the BNA Act. The word Canada in Section 91 does not refer to Canada as a geographical unit, but refers to the juristic federal unit, the corporate body, the corporation. So the Canada that we're speaking about here is that corporate body. And the criminal law that we're speaking about operates within this corporate body. When looking into the international covenants, we find the rights and freedoms that pertain to our interactions with the police force here in Canada. These rights specifically control the interactions with authority that designates itself as the police services. In the International Covenant on Civil and Political Rights, Article 9, we find the following. Every citizen has the right to liberty and security of the person. No, that's not what it says, right? Everyone. So you and I, as men and women, we have the right to liberty. And we know that liberty is what? It's a natural right. When we look at the definition of natural rights, fundamental rights, absolute rights, it gives an example of what these rights are, and it says liberty. And liberty is a natural right. That's why the everyone here is the man or the woman. We have the right to liberty and security of our person. No one shall be subjected to arbitrary arrest or detention, and no one shall be deprived of his liberty except on such grounds and in accordance with such procedures as are established by law. Anyone who is deprived of his liberty by arrest or detention shall be entitled to take proceedings before a court in order that the court may decide without delay on the lawfulness of his detention, and order his release if the detention is not lawful. And anyone who has been a victim of unlawful arrest or detention shall have an enforceable right to compensation. So we just saw in that handbook, and we just saw further in the court judgments that I shared with you, where it talked about that if the police arrest you unlawfully, that they are subject to civil charges. They can be sued civilly. And here we're seeing in the International Covenant, it's bringing out the fact that if we've been a victim of an unlawful arrest or detention, we shall have the right to compensation for these actions. And in Canadian law, if you're being charged as a police officer for an unlawful arrest, who's going to be facing the consequences is going to be you if you're sued civilly. In Graham Granton, the Canadian Charter of Rights Decisions Digest from Justice Canada, it said, read as a whole, it appears that Section 7 was intended to confer protection on a singularly human level. A plain, common sense reading of the phrase everyone has the right to life, liberty, and security of the person serves to underline the human element involved. Only human beings can enjoy these rights. Everyone, then, must be read in the light of the rest of the section and defined to exclude corporations and other artificial entities incapable of enjoying life, liberty, or security of the person, and include only human beings. The reason that everyone in Section 7 of the Constitution Act of Canada is recognized only as a human being is due to the nature of the rights and freedoms being dealt with. The rights being brought forth in Article 7 of the Constitution Act are the right to liberty and the right to the security of the person. When we come to the International Covenant in Article 9, we find that the nature of the rights and freedoms that are being spoken about are the same or similar to the rights mentioned in the Constitution Act, Article 7. We find in the covenant that the subject being brought forth is an everyone, and this everyone has the right to liberty and security of the person. The rights and freedoms are only exercisable by a human being or a man or woman. When you are standing under the designation of human being and an officer is seeking to charge you under an enactment, these rights and freedoms listed here in the covenant and subsequently in the Constitution Act are available for you to use. The police officer is interfering with your liberty by forcing interaction with you. Remember, we just saw concerning the fact that you have no obligation to identify yourself. If they come and they interfere with you, they're removing your right to have your freedom, your liberty, not to be interfered with. If you have not broken the common law by injuring someone or taking from someone something that is not yours, then the officer's interactions with you are based upon the duties and obligations coming forth from an enactment. As a human being, this is arbitrary interference. So, for example, if the officer sees you on the street smoking a marijuana joint, and I won't give my judgment whether I think this is good or bad, but if you're on the street and you're smoking a marijuana joint, and he walks up to you, and right away he wants to enforce that enactment against you, the Controlled Drugs and Substance Enactment. What's he doing? He's rendering you into a class of persons, and he's trying to enforce an enactment against you as you being a class of person. And he's arbitrarily interfering with you as a human being, and he's forcing you into a role of a person. Now, this is contrary to your rights, because you have the right to liberty, and you have the right to remain in your full legal capacity. And when I use the term or designation full legal capacity, that means you're standing with all your natural fundamental rights and freedoms, not being classed into a class of persons. In the International Covenant on Civil and Political Rights, Article 9, it says everyone has the right to liberty. And in Article 17.1 of this covenant, it says no one shall be subjected to arbitrary or unlawful interference with his privacy, family, home, or correspondence, nor to unlawful attacks on his honor and reputation. Everyone has the right to protection of the law against such interference or attacks. If you are arrested and charged under an enactment, the officer is depriving you of your liberty through this arrest. You're going to be detained, you're going to be placed in a prison cell, your liberty is gone. You can't go on your way, you can't continue on your way. As a human being, you have the right to be brought before a court, to have the lawfulness of this detention dealt with, and to be released if the detention is not lawful. In the International Covenant on Civil and Political Rights, Article 9.4, it states it like this: anyone who is deprived of his liberty by arrest or detention shall be entitled to take proceedings before a court, in order that the court may decide without delay on the lawfulness of his detention, and order his release if the detention is not lawful. This operation of law is only available for those who understand what is transpiring. There are presently millions of individuals in Canada that could exercise these rights, but because of ignorance, they have no ability or understanding how to exercise them. Canada, as a signatory to the covenants, had the obligation to bring forth these rights and freedoms through domestic law. The obligation to transfer these rights into domestic law is found in the covenant itself. Article 2, where not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional process and with the provisions of the present covenant, the provisions we just read, where it stated anyone who is deprived of their liberty by arrest or detention has the right to go before a court, and if this detention is not lawful, he's to be released immediately. And once he's released, he's allowed to claim civil damage against the one who's done this to him. Now, in accordance with its constitutional process and with the provisions of the present covenant, to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. When we look into the Constitution Act of 1982, we find the fulfillment of Canada's obligation to these rights and freedoms. The Constitution Act of Canada 1982, Article 10. Everyone, man or woman, has the right on arrest or detention to be informed promptly of the reasons therefor, and to have the validity of the detention determined by way of habeas corpus, and to be released if the detention is not lawful. The international covenants bring forth the right to liberty, no arbitrary interference, and the right to have the charge determined unlawful, to be released if the charge is unlawful, and this operation of law is called habeas corpus. The responsibility is upon the shoulders of the individual to exercise these rights and freedoms that you are seeing before you. The right to have a charge deemed or judged unlawful is something only the individual can do. In the Constitution Act of Canada 1982, Article 10, everyone, the human being, has the right on arrest or detention. A right never produces an obligation, but presents the individual an opportunity to use the right depending on the nature of the right and the circumstance. When an individual is being arrested, they would not invoke the right to vote before the police officer. Even though the individual may indeed have a right to vote, the nature of the right is incompatible with the circumstance. When you are being interfered with by the police officer, this is the circumstance in which these rights and freedoms were meant to be used. They have been preserved for us to use in these very situations. Failure to exercise these rights equals to a missed opportunity. The covenants are two-folded in nature concerning the rights and freedoms they bring forth. When dealing with the detention and arrest, the rights and freedoms recognized for the person are not similar when compared to the rights and freedoms of the human being. When looking into the Constitution Act of Canada concerning the rights that a person has, we find the following. The Constitution Act of Canada 1982, Article 11. Any person charged with an offense has the right. So you see how that's changed now? Before, in Article 10, it was everyone, the human being, on arrest or detention, and now it's any person charged with an offense. Well, if you're charged with an offense, you're going to be arrested or detained. You have the right to be informed without reasonable delay of the specific offense. You have the right to be tried within a reasonable time. You have the right to be presumed innocent until proven guilty, and you have the right not to be denied reasonable bail. So, rights and freedoms of the person to be informed of the charge without unreasonable delay, and to be tried in reasonable time, not to be denied bail. Rights and freedoms of the human being, the man or the woman. You have the right to determine, or to the determination against the lawfulness of the charge. You have the right to invoke habeas corpus. As you can see, a person has no ability to invoke the right of habeas corpus. The person in Canada is the servant of Her Majesty and owes the obligation to the enactments. That's why it's written like that in the Constitution Act. Because when the person is approached by the police officer on the street And if you're playing the class of person, then the class of person has the duty and the obligation to the enactment. And therefore, when the police officer arrests the class of person, there's no habeas corpus for the class of person. Why? Because the class of person does not have its natural rights. It's not operating its full legal capacity. The right to habeas corpus operates in the individual's favor and always must be invoked by the individual. The police officers and the justice system itself have no obligation to inform you about your right to have the lawfulness of a charge dealt with under habeas corpus. This right itself is preserved under the Criminal Code as well as the Constitution Act of Canada. When you look into the Criminal Code, we find the following article of law. So in the Criminal Code of Canada, Article 794.1, no exception, exemption, proviso, excuse, or qualification prescribed by law is required to be set out or negatived, as the case may be, in an information. If there is a provision of law that allows you to invoke habeas corpus, the opposite party is not under obligation to bring this fact forward in any way. They do not have to write it in the charges that they are laying against you, neither does the prosecutor have the obligation or duty to inform you that you can challenge the lawfulness of the charges. In the Criminal Code of Canada, burden of proving the exception. The burden of proving that an exception, exemption, proviso, excuse, or qualification prescribed by law operates in favor of the defendant is on the defendant, and the prosecutor is not required, except by way of rebuttal, to prove that an exception, exemption, proviso, excuse, or qualification does not operate in favor of the defendant, whether or not it is set out in the information. The obligation of proving that a charge is unlawful is the individual's obligation. If the individual is aware of their fundamental rights and freedoms, then they have the ability to provide an exemption against a charge, and this will play out through the operation of law termed or designated habeas corpus. If the individual has never been exposed to their fundamental rights and freedoms, then it is hopeless to expect the individual to be able to provide an exception, an excuse, or proviso against the charges. So let us look at possession for an example. The police officer is trying to charge you with possession of a controlled substance. This charge comes out of an enactment titled the Controlled Drug and Substance Enactment. He will use the articles of law located in the enactment to say that you have broken the enactment. In the Controlled Drug and Substance Enactment, possession means possession within the meaning of Section 4.3 of the Criminal Code of Canada. So under this enactment, possession means what is described in the Criminal Code. So we must look into the Criminal Code of Canada now to define what possession means. And remember, when we're talking about Canada, we're talking about the federal juristic unit. For this purpose of this act, a person, and the person here is the one who's incorporated into the federal juristic unit. A person has anything in possession when he has it in his personal possession, or knowingly has it in the actual possession or custody of another person, or has it in any place, whether or not that place belongs to or is occupied by him, for the use benefit of himself or of another person, and where one or two or more persons, with the knowledge and consent of the rest, has anything in his custody or possession, it shall be deemed to be in the custody and possession of each and all of them. So possession means a person, and that personal possession is on him. Or possession means you have something, but another person is holding it for you. Possession means hidden somewhere to use later. If you have a controlled substance on you, hidden at home, etc., and the officer finds out, the officer will seek to arrest you and will declare that you are in possession of a controlled substance according to what the enactment says. The officer will seek to bring a charge under the enactment against you. And when you look in the Controlled Drugs and Substance Enactment, it talks about once you've been charged and once you've been found guilty in the court of law and they've taken away your substance, it says here in Article 16, in that case, the judge can order that the substance be forfeited to Her Majesty in right of Canada and disposed of by the minister as the minister thinks fit. So Canada, the corporate body, is going to regulate you through the enactment and say to you that as an officer of this corporation, you have no right to be possessing such a substance as a natural created plant. Concerning this particular charge, an individual could invoke habeas corpus to have the charge declared unlawful against them. By doing this, the individual would be exercising the rights and freedoms guaranteed by the Constitution Act in Article 10 and further expressed in the Criminal Code in Article 794. The police officer will have to create or swear out an information against you and declare that you have broken the enactments and therefore he believes that you should be charged. In the information, the officer will state that he caught you with a controlled substance according to the enactment. In this information that he writes up, the officer has no obligation to provide the excuse for you as to why the charges are unlawful against your full capacity, your full legal capacity. The burden of proving that an exception, exemption, proviso, excuse, or qualification prescribed by law operates in favor of the defendant is on the defendant. It is the enactment that is the officer's authority and the court's authority. It is up to you to show them that this authority is not applicable upon you, an individual human being. The officer and the court will seek to designate and treat you as that person resident in Canada, and it is up to you not to allow this to transpire. Remember, the courts are under obligation to recognize the rights and freedoms of a human being through its inherent jurisdiction and the administration of justice. You are under arrest for the possession of marijuana, that natural plant that grows in the ground, just like apple trees and tomato plants and potatoes and grapes and cucumbers. Yes, you are under arrest for possession of that natural plant. Do you understand? You have the right to retain and instruct counsel without delay. We will provide you with a toll-free telephone lawyer referral service. If you do not have your own lawyer, anything you say can be used in court as evidence. Do you understand? Would you like to speak to a lawyer? You are under arrest for possession of marijuana. Who is the you that is being dealt with in this situation? We know that possession is a regulation that comes from the government, corporate body Canada, a created enactment. This enactment only applies upon artificial persons, class of persons, that's subject and servant of Her Majesty, the one who has been incorporated into this Canada. The officer is attempting to arrest an officer, a servant of Her Majesty, for breaking Her Majesty's enactment by possessing a substance she said her servants or officers could not. We are already aware that this possession charge is not applicable against a human being. That is why the enactment is changing your designation. You, the officer is addressing is the servant or officer of Her Majesty. You are under arrest for possession of a controlled substance. The enactment only applies to Her Majesty's subjects, and they're trying to get you to accept this designation. You cannot arrest a human being for this law, for the enactment does not apply to a human. In the Constitution Act of Canada 1982, Article 11, it says any person charged with an offense has the right to be informed without unreasonable delay for the specific offense. Now you are asked a question, and at this point the officer is taught to wait for your response. So you see, when he says you are under arrest for possession of marijuana, he's fulfilling his obligation under Article 11 of the Constitution Act. Article 11 says if you're charged as a person, so he's trying to charge you under enactment as a person, it says you have the right to be informed without unreasonable delay of the specific offense. He's telling you right on the spot, I'm arresting you for possession of marijuana contrary to the Controlled Drug Substance Enactment. That's what he's declaring to you. Now, the next thing that he's going to say, you're going to be asked a question, and at this point, the officer is taught to wait for your response. I don't even know if they're taught why they're taught to wait for your response, or if they understand what's transpiring in this interaction, but nevertheless, he's taught to wait for your response. And yes, I have to admit, sometimes I do watch a television program. I don't have cable and I don't watch TV, but I came across this Canadian border security on the internet and I like to watch it. I find it funny. And a lot of times when they try to arrest these persons that are crossing the border, they read their Miranda rights or they read them the Charter rights. And then they stand there and they wait for the individual to respond yes. And sometimes they stand there for 2 or 3 minutes or they reread their rights and they're waiting for that individual to give them an affirmation of yes. And they don't even realize what is transpiring. They're just following a procedure that they've been taught. Now, he is obligated by domestic law to get you to respond, and the response he is looking for is an affirmation from you of yes. Do you understand? Yes, I understand. At this point, you are not being asked if you understand mentally what he is saying. It is a trick that is being played against us as individuals. Remember that this state party, including their agents, cannot force you into recognition as an artificial person in law. And what covenant article brings that right forth? In the International Covenant on Civil and Political Rights, Article 16. Nor can they force you to serve Her Majesty or her enactments. Since this enactment only applies to the artificial person, who is a subject and servant of Her Majesty, the state party, must get you to agree to accept this designation. If they did not ask this question and trick you into accepting this recognition, then they would be in breach of their international obligations. They would be forcing you into servitude to these laws and into recognition as a person. So they trick you by asking you this question, do you understand? This question, do you understand, is asking you if you accept to be designated as a person, as the officer of Canada, as that resident of Canada, and to agree to be governed by the enactments. Understanding, the process of comprehending, the act of a person who understands something, one's personal interpretation of an event or occurrence, an agreement, especially of an implied or tacit nature. Understand or understanding, an agreement, an implied agreement, resulting from the express terms of another agreement, whether written or oral, a concurrence as to its terms. Again, I do not believe that the officers are aware of what they are actually doing. They are taught to read these rights off and to proceed to arrest the person. As you can see, it's a very disgusting game that is being played with individuals. If you are not aware of your individual human rights and just what is transpiring in these laws, then you will not know how to defend your interactions with the justice system. At this point, your answer to the officer who is detaining you and seeking to charge your person is, no, I do not understand. I am invoking my individual human rights as enumerated in the Constitution Act of 1982, Article 10. You either let me go right now or bring me to the judge so I can have the validity of your charge dealt with under a writ of habeas corpus. Now, if the officer continues to read you your rights, he will say the following. Anything you say can be used in a court as evidence. Do you understand? Now here, the officer is stating that anything you say will be used in court as evidence against you. Another way of phrasing this is say anything and we will go to court. Example, officer, it's just a small amount of marijuana. Oh, but officer, it's just my friends. I'm just holding it for them. Or, oh, come on, officer, just give me a break. Please, please, I promise I won't do it again. Or, hey, officer, it's just for my personal use. If you say anything, then it is tacitly agreed that you have accepted the designation as that person in law, and they will continue to try and charge you. because once you start to justify the position, then you've tacitly agreed to accept the designation of the position. You've lost your full legal capacity, and you've now been rendered into a class of person who owes the obligation to the enactment. You again need to respond with the fact that you do not understand. You do not accept these charges, nor to be designated a person or servant to the corporation. These charges and are invoking your charter right as indicated in Article 10 of the Constitution Act of Canada, 1982. There are times that the officer can let you go on the street right there with an undertaking or a promise to appear. This is simply your promise to appear in court on the date that they give you to defend against the charges. This is not something you want to do or agree to, for it tacitly places you into position of servant of Her Majesty who is accountable to these enactments. Again, undertake, to take once on oneself, to engage in, to enter upon, to take in hand, to take upon oneself solemnly or expressively, to be surety for a promise, to accept or take over as a charge. So you don't want to be involved in that type of operation of law when you're dealing with the police officers. Your interaction with the officer, if you are being detained or arrested, is not to stand under what they are trying to do. You must inform the officer that you do not stand under these charges and you are invoking Article 10 of the Constitution Act of Canada, 1982. And after that, be silent. Remain silent. Don't answer questions anymore. Now, one important fact to remember is the following. Well, before I get into that, remember it's not the officer you're fighting. The system is set up in the laws, in the enactments, in the regulations that's been created. These men and women are just following procedures. They're only out there. Why? Because they're pursuing earning and gaining after a living. And let me tell you, they see the worst of society every day. And I'll just leave it at that. Now, one important fact to remember is the following. While Section 7 of the Charter guarantees the right to remain silent, Canadian law does not entitle the criminal suspect to have counsel present during the course of an interrogation. Once a suspect has asserted their right to counsel, notice that, once a suspect has asserted their right to counsel, the police are obligated to hold off in attempting to obtain evidence until the suspect has had a reasonable opportunity to contact legal counsel. However, suspects do not have the right to have counsel present during the questioning. Also, in Canada, even if suspects emphatically assert his decision to remain silent, the police may continue to interrogate him, although this may give the suspect the impression that his claim of the right to silence is meaningless or that he has no such right. It is perfectly legal, and that you find in R versus Singh. So even though you remain silent and the police can keep trying to push you and keep trying to question you, and it's considered okay for them to do that. The suspect invoked his right to remain silent 18 times, and the police nevertheless continued to question him after each assertion of his right. But the Supreme Court of Canada found this consistent with Canada's Charter's rights protection. Now understand something here. The suspect that they're talking about, the capacity that he's operating under is not his full legal capacity. He's not operating as a man or a woman under his fundamental rights and freedoms. He's already accepted or walked into the role of the officer of Canada, that federal juristic unit, and as such he owes that duty to the enactment. And that's why he was treated that way. After they have arrested you and have placed you in the vehicle, it is again at this point that you need to inform them that you are invoking your constitutional right under Section 10 of the Constitution Act of Canada 1982. Our common law rights exist in Canada. However, it is through the Charter that we must enforce our rights and freedoms. Remember, in the Interpretation Act of Canada, it says both the common law and the civil law are equally authoritative and recognized sources of law, of property, and civil rights in Canada. And the Supreme Court has made it clear in cases M.A. versus Ryan that common law must develop in accordance with the Charter values. A trespass in common law equals an infringement or denial of a fundamental right and freedom. The police, in this interaction with you, through the procedure they are using, are trying to get you to play the role of artificial person, that officer of Canada, the subject and servant of Her Majesty's kingdom, and accept this designation. This is a violation of a number of our rights and freedoms. such as the freedom of association, the right to liberty, the right not to be held in servitude, the right to decide if we would play the role of a legal person. The procedures the police were taught and are using are violating our fundamental rights and freedoms. Remember that every individual in Canada has the ability to invoke their fundamental rights and freedoms as contained in the Charter and international law. In the Constitution Act of Canada, 1982, Article 10, it says everyone has the right on arrest or detention. Remember, so the right is being brought forth. Why? Because we're being placed in this situation. If the situation of being arrested or detained didn't come up, we would never have to invoke this right that we have. But everyone has the right on arrest or detention to have the validity of the detention determined by way of habeas corpus and to be released if the detention is not lawful. At this point, since the officer is seeking to charge you under an enactment, you must challenge the validity of this charge under the action of habeas corpus. The officers, uh, you have 3 days to bring you before a judge. The officers have 3 days to bring you before a judge in order to determine if the charge is valid or not. Once you are brought before a judge, you will have to explain to the judge that this arrest has violated your guaranteed fundamental rights and freedoms as expressed in the Constitution. You would further have to show the judge why this is a violation of your rights and freedoms by showing that the officer's actions were a restriction of at least one of your rights and that this was done contrary to the principles of fundamental justice. If you fail to invoke your fundamental rights and freedoms, you will be treated as a person, and you will have to defend against these charges just like anyone else would have to do. In the Constitution Act of Canada 1982, it says everyone, you, the man or the woman, has the right on arrest or detention to be informed promptly of the reason thereof or therefore. So the officer declares to you that he is arresting you and charging you under the Controlled Drug and Substance Act. The officer then further informs you of your right to obtain counsel. These are the officer's only obligations or duties towards you under this operation of law. Why? Because in the Constitution Act of Canada 1982, it says you have to be informed promptly of the reason of your arrest, and you have to be told that you have the right to have counsel. And that's what the police officer is doing. Now, the next part of this constitutional right is something that is your responsibility to perform. To have the validity of the detention determined by way of habeas corpus and to be released if the detention is not lawful. In this example, the officer laid an information against you, claiming you are in breach of the enactment titled the Controlled Drugs and Substance Act, that you were in possession of a controlled substance. You would now have to invoke your charter right to habeas corpus and ask to be brought before the judge. The police officers, I am sure, do not understand about what you know. He also has no obligation to write down any of this in this information, even if he does know. If the officer does know that you, as a human being, cannot be charged under the enactment, he has no obligation or duty to write down any of this or inform you of any of this. Because in the Criminal Code of Canada, which controls his duties, it says no need to negative the exception. No exception, exemption, proviso, excuse, or qualification prescribed by law is required to be set out or negative, as the case may be, in an information. So the police officer is laying the information against you, and even if he understands that this enactment only applies to classes of officers, he has no obligation to write it in his enactment. The burden of proving this is upon you. The burden of proving that an exception, exemption, proviso, excuse, or qualification operating in law operates in favor of the defendant is on the defendant. You would then have to explain to the judge that you know what is transpiring and that these charges are a breach of your natural rights. These enactments do not apply to you as a human being. Now, just saying this statement here that I'm sharing with you is not enough. You have to walk them through the principles of justice, starting from international law, going into the Constitution Act, going into the enactment. You have to make sure that you're in a court where you can access the inherent jurisdiction. so you can seek the administration of justice. Just walking into the court and saying, I'm a man, I'm a woman, your enactment doesn't apply to you, is going to get you in trouble. Remember, Canada will unilaterally apply their laws against you subject only to the Charter. You have to prove to them that a principle of justice is being transgressed. This enactment is a government-created enactment. It is not an expression of our natural law or natural rights. This enactment only applies to the person or officer of Canada. Again, you cannot just simply say, I'm a human being, so these charges do not apply to me. Your obligation is to prove that you have fundamental rights and freedoms, and that these charges have restricted your ability to stand and exercise your rights. That all that they've done to you is contrary to the principles of fundamental justice. And if you're able to do that, then the courts are under obligation to produce a remedy on your behalf.